So here we are at St John the Baptist Church in Burscough, and today we're going to examine King and Dubrey, a case on Donatio Mortis Causa, deathbed gifts. So let's go and have a look. Hello, well here I am, as you can see, at St John the Baptist's Church in Burscough, and I'm in the graveyard, which is important because I want to talk to you about King and Dubrey, which is a 2015 Court of Appeal authority on the subject matter of Donatio Mortis Causa, the idea of deathbed gifts. And that's why it's apposite that of course we're in this graveyard, because it's here that people reside that will have made wills, well, hopefully. This is a very interesting case, not least because Lord Justice Jackson brings together all of the disparate authorities on Donatio Mortis Causa and explains exactly what it is that needs to be extant in order for there to be a valid deathbed gift. And in so doing, of course, Lord Justice Jackson also severely curtails the operation of such gifts, of these inter vivos, non-testamatory gifts. And he does that primarily because, of course, he's trying to re-establish the idea, or cause the idea to be more solidly taken on board, that the rationale for the 1837 Wills Act is adhered to, namely for transmission of property, proper formalities should be adhered to, including the signing and witnessing by two people of the passage of property by will, by that deed. Because of course an inter vivos gift in the nature of a Donatio Mortis Causa gift, a deathbed gift made during life, subverts that legislative intention. So walk with me as we discuss the facts in King and Dubrey. Well, it's a very interesting case because we have this delineation, this difference between, on the one hand, a will that was made, or groups of wills, actually a number of different wills, on the one hand, and then supposed Donatio Mortis Causa. So we have June, she's an auntie, and her nephew, who is of course King, who is Kenneth King, comes to live with her and take care of her during the twilight of her life. She was a police officer, served for a long time in the police force, and was a great lover of animals. And indeed in her 2008 will, she made dispositions to 7 different animal charities, and she had 3 dogs and 2 cats, a great animal lover. However, when Kenneth moved in with her, he purported, and indeed he helped her to draft 2 wills that differed from that original 2008 will, because all of her property was given to him. He also contended, when she died, that she'd had a conversation with him some 5 months before her death, and that in that conversation she purported to say that he will need this, and she passed over the title deeds to the house to Kenneth. Ergo, it was Kenneth's contention that she had meant to make a deathbed gift, a Donatio Mortis Causa, and that Kenneth should be the recipient of that deathbed gift. So when she dies, the various charities and the other legatees attempt to take, pursuant to the 2008 will, he litigates, he brings a cause of action, and at first instance he's successful in arguing that there was a valid deathbed gift. However, the charities are obviously vexed at this outcome because the property, the subject matter, is worth about £350,000. So they appeal up to the Court of Appeal, which is why we find ourselves before Lord Justice Jackson. And Lord Justice Jackson takes the view that the first instance judge was wrong. He'd erred. And why had he erred? Well, basically because the effect of the two supplementary wills that Kenneth had written on behalf of June invalidated the Donatio Mortis Causa. Because why would you, or how could you, make a valid disposition such as a Donatio Mortis Causa if in fact you'd already given away your property by way of will? Not the 2008 will, which was the one that ultimately came to pass as being the valid one and therefore benefiting the charities, but instead the two supplementary efforts that Kenneth had drawn up. And as counsel for the charities highlighted, and indeed Lord Justice Jackson highlights, Kenneth was a chap with perhaps a slightly dubious past. He'd been bankrupted twice, he'd been disqualified as a director, and indeed because he continued to act as a director whilst disqualified, he was imprisoned for obviously a dishonesty offence. So whereas the first instance judge was prepared to accept, albeit with some caution, Kenneth's evidence about this deathbed gift, Lord Justice Jackson actually didn't decide on this point but made reference to it, which is interesting. He instead, however, found that the three extant reasons that can cause a Donatio Mortis Causa to happen were not present, namely the idea that the donor, in this case June, was contemplative of her impending demise. She wasn't. There was nothing wrong with her. She could have gone to the solicitors and got another will drawn up, but she didn't. Why is that? Similarly, of course, the gift, in terms of an intention for it to pass on her death, whether or not that was extant, Lord Justice Jackson found that it wasn't. And then thirdly, of course, some form of passage of property must have occurred. That did happen in this instance. That's to say the title deeds were given to Kenneth, who then put them in his wardrobe for safekeeping, I suppose. But the important thing for us to think about with this 2015 authority is that Lord Justice Jackson is very circumspect about the operation of Donatio Mortis Causa. He wants this operation to be curtailed heavily. And it's therefore on that point that from here in St John the Baptist graveyard I leave you on this blustery day to contemplate yourself, not your impending demise hopefully, but the case of King and Dubrey. Goodbye.